Good morning, everybody. Continuing with video number 2 in our series, Things You Must Know Before You File a Chapter 7 Bankruptcy. So last time we discussed the threshold issues of whether you qualify vis-a-vis your income and whether you've done a bankruptcy in the past 8 years. If you have, you can't do it. If your income is over the cutoffs, you can't do it. If your income is over, you probably can do a Chapter 13, but we've talked about that in other series, and we will talk about that more in future series. So today we're going to talk about another thing you need to know before you make a decision on filing a Chapter 7, which is what type of debts do I have, and are they dischargeable? So here's the big ones you need to know. Student loans, not dischargeable, although if you get rid of all your other debt, it's going to be a lot easier to pay off that debt. But as it stands now, student loans, and by that I don't mean a loan that was used for tuition. I mean a federally backed student loan. Generally, you're going to go through the FAFSA process, and those are going to be guaranteed by the government. Those are absolutely non-dischargeable. Child support, also non-dischargeable. So if that's one of the debts you're considering, Chapter 7 won't help you. Criminal penalties, restitution, things like that, not dischargeable. Chapter 7 won't help you there. Although certain civil penalties, or I should say more civil reimbursement, if the city mows your lawn because you didn't and cited you, that cost can be discharged in a bankruptcy. Support alimony, generally non-dischargeable. Drunk driving, related personal injury judgments against you are not dischargeable. Fraudulent debts, someone's sitting out there, is going to say you defrauded them. They may, if you list them in the bankruptcy as a debt you're going to discharge, they may jump in, file an adversary, and come after you. So you want to consider who's out there, because you have to give notice to every creditor that is humanly possible to do so. And also bear in mind your secured debts. So if you're going to wipe out a debt that is secured, properly secured by collateral, you're going to have to give that collateral up. So certainly keep that in mind. It's not a get rid of the debt but keep the collateral kind of deal. So unless there is some error in the way that they've perfected their secured interest. We'll talk more about that in another series. But these are the things you need to consider from last week. Do you make too much money? Have you done a bankruptcy in the last 8 years? And second, is your debt primarily student loan debt, child support debt, criminal penalties, alimony? Another thing we talked about in another series, if you are assigned a debt in a divorce, say you have a credit card with your ex-wife, you are assigned by the divorce court responsibility for that debt. You can discharge it in bankruptcy, but your ex-spouse can still come after you for contempt. So bear that in mind. If that's what you're getting out from under Chapter 7, may not be the best deal for you unless you can, if you're in the process of divorce and can get her or him to do it with you. So those are more threshold issues, and we'll look at more things you absolutely must know before you determine whether you want to file a Chapter 7 in the next video. As always, you can reach me directly at 188-DEBT-LINE or email me at edward@wirthlawoffice.com, WIRTH lawoffice.com, and I'll see you soon.